Yes, my ladies and lords, I was coming on to address the question of subsection 3CB and the differential treatment which on the appellant's view is said to arise between those born before and after 1949. And as I understand it, the appellant's position is in effect that where one sees the reference in subsection 3CB to application for registration, that must be taken to include consular registration, and therefore it would exclude those otherwise falling within assumption B for the period pre-1949. And that, it is said, in effect, supports the appellant's arguments regarding section 3D in turn. In my submission, there are two answers for the respondent to this point. The first is that subsection 3CB does not, in my submission, encompass reference to consular registration. The second is that even if it does, in my submission, it makes no ultimate difference to the respondent's interpretation. Dealing with the first of those 2 points, there is in my submission a distinction between, on the one hand, application for registration and the term registration when used alone. And I'll come on to indicate some provisions where certainly one of those can be found. Application for registration in my submission, the Inner House recognised that the difference is not merely textual. Application for registration, properly understood in my submission, involves a request to the relevant authority, either to exercise discretion or to grant status as a matter of entitlement, provided that necessary conditions are met. But the critical act on an application for registration is that of the authority to which the application is made. By contrast, registration alone, in my submission, without the application, should be understood as an act brought about solely by the person who has addressed themselves, him or herself, to the administrative authority, rather than the act of the authority itself.
It may be you can, as well as focusing on the word application, also you can focus on the words as a person who has the status in question.
Quite so, my lord. I was coming on to make that point, is that dealing with the first of those, in my submission, in terms of section 4C itself, one can see that the distinction between application for registration and registration is recognised in section 4C itself. The very premise of section 4C, particularly at subsection 1, is that a person is entitled to be registered if he applies for registration. That's subsection 1A. So the section itself envisages an application for registration, and one sees, of course, the same term repeated in the subsection which is currently under discussion, subsection 3CB, but it's, in my submission, significant that in subsection 3D, by contrast, Parliament has referred only to registration. So
are you construing the words "who has the status in question" as determining the status of the applicant before his application, or the status which he would acquire by virtue of registration? I think you're construing it in the former sense. Is that right?
Lordship, excuse me a moment.
The words "who has the status in question," does that mean that he is applying as a person who already has that status, or he is applying for a registration which will give it to him?
I had rather read it in the latter,
right,
Lord, as being an application for to obtain the status in question.
And that fits with the, no doubt you're going to come to them, there are various other provisions which have a similar form of words and where the status is the consequence of registration.
Precisely so, and examples of those. So the point is made that there's a distinction between application for registration and registration in terms of the section. Other examples which expressly incorporate the words application in one form or another, application for registration, one sees one of those, and for example, going back to the 1948 Act, one would see it in section 7 of the 1948 Act. I won't take the court to it unless they wish me to, but it's to be found at tab 11, MS 349. And that's
the whole section of the Act headed Citizenship by Registration, which is sections 6 to 9 inclusive.
Of the
1948.
Of the 48 Act, indeed, my lord. And then when one comes to the 1981 Act, there are many examples of application for registration. Section 3 would be the equivalent to Section 7 of the 1948 Act. That's tab 7, MS 328. That's the application for registration of a minor child, either in a discretionary decision or as a matter of entitlement.
What section is that?
That's Section 3, my Lord. It's at MS 328.
Well, as a sort of general proposition, you could acquire citizenship by birth or by descent or by naturalisation or by registration.
Yes.
Those different methods. But am I not right in thinking that registration as a separate category was a creation of the 48 Act?
I accept that in those terms, my lady, yes, it is a
Which
creation.
makes it rather puzzling to have it in the bit that's about pre-1949 cases.
I don't disagree with that, my lady. It is puzzling, and I think it explains why one assumes that Parliament intended to give it content, and that's why one saw the example that the Inner House had regard to, which Mr. Johnson referred to. In other words, sections 2, sections 5, and sections 2, 5, and 19 of the 1914 Act. Those are at tab 12, MS 373, and that was the question of naturalisation of a minor. Because what one has in terms of section 2 of the 1914 Act was that the Secretary of State, of course, had discretion to grant a certificate of naturalisation to an alien who made an application. In terms of section 5, the Secretary of State had the discretion to include the child of the alien on the certificate. And of course, that certificate in due course would be registered, particularly by reference to the regulations which the Secretary of State was empowered to pass under Section 19. Now, I accept it's an example that the Inner House has had regard to in an attempt to give content to application for registration. I accept, of course, it's not a perfect fit because it's a two-stage process. The application is for the naturalisation, or more importantly, for inclusion of the minor on the certificate of naturalisation under Section 5. And I should say, I think the Inner House were not dealing with Sections 2, 5 and 19 separately. It respectfully seems to me that they were regarding them as a singular process. But the application is the inclusion on the certificate, the registration comes after that. It is not a perfect fit. I accept that, my lady. If that is what Parliament intended, then one could readily see the reason for excluding that. Because if one thinks about the precursor to inclusion of the child, the naturalisation of the adult in the first place would be entirely discretionary. And the discretion at Section 2 of the 1914 Act would extend to matters such as the Secretary of State's consideration of whether the adult was of good character. And one could see that there would be good reason for excluding an ex post facto consideration of matters of discretion of that nature, of good character of somebody going back in time, as distinct from consular registration. I say this much I suppose, in direct response to my lady in the chair's question, which is that if it is an anomaly, if it is difficult to give content to application for registration, well, the fact remains in terms of the section itself, the two different terms appear in the same section. So one, in my submission, it is reasonable to assume that Parliament intended to give application for registration a different meaning to registration alone. And if that is the case, in my submission, consular registration would fall readily within the latter but not the former category. If there is an anomaly in that it is difficult to give meaning to application for registration for the pre-1949 period, well, in a sense, from the respondent's position, I accept that. But in a sense, it would be surprising if either side came through the process of interpreting Section 4C entirely unscathed in terms of anomalies.
As currently advised, impossible.
And I think the simple point I make is that if that is the anomaly which is said to count against the respondent, then in a sense it is a far less invidious anomaly than one which involves an interpretation of Section 4C which in effect perpetuates discrimination. I think the only other point to raise the one that my Lord Reid has raised, yes, my submission, one can also have regard to the words at the tail end of that, as a person who has the status in question.
The status in question presumably is a nationality status.
Indeed, my Lord, yes.
And registration of birth is merely recording the fact of someone's birth.
Lordship, my Lord has anticipated exactly my
Yes,
point.
and so
Simply
within the UK, it's not a question of applying for it, it's a question of being under a statutory obligation to register it.
Indeed.
You have to tell the authorities that you've had the child.
And even in the context of making a choice to consularly register, which would not be a matter of duty but a matter of choice, nevertheless, it is simply a registration of birth de facto and no more than that. So in my submission, for all of those reasons, subsection 3C(b) does not include consular registration. It is therefore not taken out of the equation in relation to the pre-1949 period, and the consequence of that in my submission, that any question of differential treatment vis-à-vis the period pre and post 1949 melts away.
There's just the oddity that when they did get round to putting 4C in, they didn't deal with the period of 83 to 88.
I'm just coming on to that, yeah. Lord, indeed. That takes away, at least takes away the oddity of that period. If I were to be wrong about it, if I were to be put it this way, if I were to be wrong about that, and the intention was to preclude consular registration pre-1949, well, it doesn't necessarily make the respondent's argument wrong in relation to the period post-49. It may be, I suppose, one explanation. Of course, it's very much a secondary position in my submission, but it would be conceivable that Parliament had decided to, in effect, draw a line in the sand in the same way as the Section 4C did in its original form. It drew a line in the sand at 1961. It is conceivable, I suppose, that Parliament might have drawn that back to say, well, we'll go back as far as the introduction of the 1948 Act, but no further than that. Because in 2009, by the time these amendments were introduced, anyone pre-49 who might be covered by that stage, I suppose, would be 60 or over. They would be less likely to be seeking citizenship of the UK. They're more likely to be settled elsewhere, and presumably their parents are more likely to be deceased by that stage. So if I'm wrong about what I say, then in my submission, there is at least a rational reason for why Parliament would draw a line in the sand in relation to the pre-1949 as compared to the post.
Slightly crab-like way of doing it.
Sorry?
It's a slightly indirect way of doing it.
Of doing the...
Of drawing a line in the sand. I mean, most lines in the sand are intended to be clearly visible.
Well, I don't disagree with that, my Lord. I mean, it really brings me back to the point that that's very much a secondary submission that I make. My point is that it simply doesn't cover consular registration at all. Therefore, there is no differential treatment.
It only arises
at all.
if you lose on point 1.
Indeed. So that really covers the question of Section 4, subsection 3C(b), and that brings me then to deal with the question of the differential treatment in relation to those born after 1983 as compared with those born before that date. And that is a result, of course, of Section 9 of the 1981 Act, which we've already looked at. And, of course, I accept that that is the case. There has been a decision by Parliament in 1981 to continue, despite the overall aim of 1981, the 1981 Act, because I asked the Court to bear in mind, the 81 Act was the Act by which, of course, Parliament did away with discrimination, gender discrimination, prospectively, with the exception of this transitional provision in terms of Section 9. And of course, having recognised that, it is equally clear that Section 4C does not retrospectively remedy the discrimination suffered as a result of Section 9. That's clear from the first condition of Section 4C, because the first condition is that an applicant must be born before 1983. So self-evidently, it does not cover those. Now, I make the initial point I make is that whilst Parliament's intention in 2009, when carrying out these amendments, was plainly to broaden the remedies available for historical discrimination, it does not necessarily follow that in doing so it must have sought to be exhaustive. Again, I make the point that 4C in its original form was not exhaustive. It only drew back to 1961. On my interpretation, in 2009, Parliament has gone further than that and gone back beyond 1961, but has not addressed this anomalous period of 83 for the 5 years after 83. I appreciate, of course, Parliament must be taken to have been aware in passing these amendments to 4C. Parliament must be taken to have been aware of Section 9 of the 1981 Act and must be taken to have made a conscious decision not to include reference to it. But in my submission, it is relevant to take account of the fact that in 1981, Parliament took a deliberate decision to enact Section 9 and to retain, positively to retain, an element of discrimination in nationality law, at the same time as otherwise seeking to eliminate past discrimination or prospective discrimination. And it is also notable in my submission that Section 9 was a transitional provision which was later, in 1986, the subject of a specific reservation to the United Kingdom's treaty obligations under the Convention for the Elimination of Discrimination Against Women. Because, as the Court will have seen from the respondent's written case, particularly paragraph 16, the terms thereof are set out there of Article 9.2 of CEDAW, the Convention of the Elimination of Discrimination Against Women. And Article 9.2 provides that parties shall grant women equal rights with men with respect to the nationality of their children. The reservation which was entered by the United Kingdom upon ratification made express that their acceptance of 9.2 was to be subject to and would not invalidate the continuation of certain temporary or transitional provisions which were to continue in force beyond that date. So an express reservation was entered by the United Kingdom which validated Section 9 despite otherwise the attempt to comply with Article 9 of CEDAW. And in my submission then, Section 9 can be seen in 1981 as a deliberate decision by Parliament, a deliberate decision later subject of a specific reservation, and a deliberate decision therefore to continue with discrimination. And when one bears that in mind, in my submission, one should take it that Parliament in 2009, in enacting the amendments to Section 4C, should be taken to have decided to remedy the historical discrimination prior to 1983, but to leave untouched the discrimination which was deliberately enacted by Parliament regarding the 5-year transitional period. In other words, it is understandable as a decision by Parliament in 2009. One may question it on terms of how it fits with the overall aim or in a political sense. There might be questions arise to it, but in terms of a deliberate decision being taken by Parliament, it is an entirely rational decision to say we will correct everything pre-83, but insofar as our predecessors in 1981 took a very deliberate decision and entered reservations in relation to our treaty obligations in respect of it, to continue with that for a limited period, we will leave that untouched. That was a deliberate decision by Parliament. It is not otherwise a historical element of gender discrimination which requires to be dealt with. So in other words, in my submission, that does not detract from the meaning of the words in Section 4C, in my submission, dealing with the pre-1980 period with which Parliament was plainly concerned to find a remedy for. Unless I can assist further with that issue, that really just simply brings me back around to the question of whether or not Section 4C is workable. I think I've largely addressed that. I simply make the point again that, yes, it is true that it involves consideration of an unusual past hypothetical, but it is workable. In my submission, if one puts oneself in the shoes of the decision maker, it is workable on a case-by-case basis. And it is simply the fact that this past hypothetical question requires to be considered in my submission is simply the net result of the way in which Parliament has sought to remedy the past discrimination. It's a necessary result of it, And it's incumbent in my submission on the Secretary of State to address this on a case-by-case basis in the same way as the court would have to if it required to deal with it. And that really brings me to the last point which I intended to make. And it's one which really simply continues a thread which has featured throughout much of what I have already said. In my submission, this is no doubt a very difficult statutory provision. It's unhappy in much of its wording. I'm sure the court has noticed that Fransman in his commentary on it described it as being dense and impenetrable. In my respectful submission, it is undoubtedly dense. But when one seeks to do so, it is ultimately penetrable for the reasons which I've suggested.
Well, it has to be penetrated.
Well, indeed.
We
yes.
have no option.
It doesn't really.
We have to decide one or other of you is right.
Indeed. And the point I ultimately make is that my point is it is penetrable. It is penetrable without any reasonable ambiguity about it, because the factors which I place weight upon in my submission are weighty ones which count in favour of the respondent's interpretation.
There is an alternative possibility, which is that some parts of this provision are simply insensible and cannot be given effect to. Certainly cannot be given effect to in such a way as to produce a discriminatory disqualification from rights as basic as citizenship, without the position being made rather clearer than Parliament has sought to make it. There are a number of provisions whose insensibility might lead to the result that you contend for. But it's a possibility one's got to take into account.
Well, it might not surprise the court here that I wouldn't demur from that as a possible outcome. Of course, I'm here to contend for a positive interpretation which favours the respondent. If the court were to come to the conclusion that it is insensible to the extent that it cannot then be held to apply to discriminate against the respondent, then so be it. I recognise that that is an alternative route. The concluded matters that I was about to make is that if the court is left with in the conclusion that there is ambiguity, then in my submission, the court should be entitled there to look to the domestic principle of interpretation, which means that if the statute is ambiguous, the court should prefer the meaning which relates the scope of the provision most closely to the mischief which it was intended to remedy. That's, I think, well, no doubt, an aid to statutory interpretation the court is well familiar with, for the avoidance of doubt. It's, I think, most famously well-known passage in which it's stated is that of Lord Reid in the Black Clawson case, which is not within the bundle, but it's to be found in 1975 appeal cases, page 591, in particular at page 613 to 614. And in the present case, in my submission, the mischief is the remedying of historical gender discrimination, all the more so in the 2009 context where the scope of that remedy is being widened. And the respondent's interpretation relates the scope of section 4C most closely to that mischief by taking the broader interpretation of the discrimination which is to be remedied. The alternative in my submission is to read it in the appellant's way in a more restrictive manner to exclude an entire category of those who are discriminated against otherwise. And not just that, in my submission, due to the way in which they interpret the section, it is to do so in a way which positively perpetuates the discrimination, because they're looking back to say you cannot rely on section 5.1b because you could not have registered because of the discriminatory nature of the law at the time. And in my submission, in those circumstances, if there is ambiguity there, the court should prefer the respondent's interpretation as being conform to that general aim of section 4C and the widening of the discrimination. And in passing, I simply mentioned, of course, that to take that view would also be to arrive at an interpretation which is at least consistent with the United Kingdom's treaty obligation. Article 9.2 of CEDAW, which I've already mentioned, plainly intends that there should be equal rights granted in respect of women's rights to pass on nationality to their children. This is an interpretation in my submission which is consistent with that treaty obligation. Ladies and lords, unless there's anything else I can be of assistance with, that's all I think I can usefully add, and I simply move the court to refuse the appeal.
Thank you very much indeed. It looks as if there are no further questions to fire at you. Thank you. Ms. Irvine, do you follow?
My lady, if I may, there are just a few points which I'd like to address. The first relates to the scope of the discriminatory provision as it's been described, Section 4C, in other words. As we know, the section was amplified considerably in its 2009 incarnation as compared with where it stood in 2002. And the court has already seen that what began as a provision addressing only Section 5 of the 1948 Act was broadened out to cover other provisions of that Act as well as legislation that preceded it. So on any view, it was a widening exercise, but, and that won't be in dispute between the parties. Where there is, I think, an issue between the parties is whether the change between those two formulations of Section 4C had any effect on the proper interpretation of its application to Section 5(1)(b). And it's my submission, as I said this morning, that one should not regard this as a case in which Section 5(1)(b) was originally, in the first incarnation of the section, a more liberal, a broader section, which was then cut down by the redraft in 2009. Rather, in my submission, the treatment of Section 5(1)(b) would be the same, whichever of those versions one was looking at. So that I would not accept that there's any kind of anomaly insofar as the Act is with one hand giving and with the other taking away. In my submission, that would not be a proper characterization. A somewhat related point arose just a moment ago in what Mr. McBrearty said about the mischief. I take no issue with the case to which he referred, but the reality is it's a somewhat question-begging formulation. One needs to know what the mischief is. The precise question before this court is, to what extent was Parliament seeking to address historic gender discrimination in earlier legislation? Even on the respondent's position, it clearly wasn't intending, as we know from what was said about Section 9, to remove all possible discrimination of all kinds against anybody at any time. It was a more limited exercise. And in my submission, therefore, recourse to the notion of mischief doesn't really assist, I would respectfully suggest, the deliberations of this court in seeking to identify the meaning of the relevant provisions. That was my first point. I think I have four. The second point relates to registration. And I should make clear, in case there was any doubt about it, that the position I advance is that if there were, in fact, people who managed to register their children at a time when, as a matter of fact, that was not possible legally, then the consequence is, as I submit, that the registration was invalid. And that follows from the primary legislation, but it's clearer in the secondary legislation. And perhaps I could just give the references to that. This morning I drew the court's attention to the 1948 regulations, which are in tab 16, and indeed I read out the very provision that's material here, Regulation 5.4 on MS 459. And if I could just remind my ladies and my lords of what it says on 459, the consular officer must satisfy himself fully that the national status of the person whose birth he's requested to register is such that the registration could properly be effected under these regulations. So that we know that is a prerequisite of making the registration. And there are equivalent provisions in the following tab under the 1974 regulations. It's perhaps worth touching on Regulation 10, where we can see at the bottom of the same page, registration of births made under Section 5(1)(b). And this is a point that arose at the end of Mr. McBrearty's submissions just a minute or two ago. And in my submission, while it's, of course, true in a sense to say this is about registration of birth, the reality is that when one takes account of Regulation 5.4, it is only births that meet certain criteria, namely that they can be properly registered, that are eligible for consular registration, and which therefore have the effect not simply that the birth is registered, but concomitantly with that a particular status is acquired. So that is, as I would submit, too narrow a point to say one can draw a clear line in the sand or otherwise between registration of birth and registration which has an effect on status. The reality is here, the registration of birth has that effect.
Well, perhaps it wasn't so much that the registration has a certain consequence, as that in 3CB, the language used of registration as a person with a certain status is very similar to the language found in the provisions in the 1948 Act to do with registration, with the acquisition of citizenship through registration.
Yes.
And one might view 3C as essentially definitional, as explaining what is meant within subsection 3B by nationality status being acquired by descent.
I see the force of that, my lord. I think I can't really add to what I said this morning. For the reasons I set out there in my submission, when one looks to the purpose of the legislation, one can divine a purpose in construing this provision so as to cover consular registration, albeit one may, as often, say that the drafting could have been better. But I take your lordship's point, however. There was, of course, no registration of this type before 1949, a point that I think Leigh mentioned earlier. My third point is very brief in relation to the meaning of assumption. Mr. McBrearty suggested we look to the Oxford English Dictionary, which is not a bad place, but if one looks at the Oxford Dictionary and finds that assumption is something that one takes for granted, in my submission, that's really not helpful for looking at these statutory provisions, because properly regarded, these are statutory provisions which set up a legal fiction that the law was otherwise than it truly was, say, in 1948. And so one's not taking anything for granted. It is really the territory of what I think Mr. Justice Turner called an immutable premise. The person applying the legislation is being directed to assume, on the basis of a legal fiction, that the legislation was in a form other than as a matter of history it actually was. But that's not really something that's taken for granted. That is, I think, to water down the statutory wording assumption and the cognate word assumed in subsection 3D. I think the only other point, the fourth point I'd like to address, is the question of what we've been calling workability. And in my submission, in the course of today's hearing, a number of points have arisen which suggest, I would respectfully suggest, support the appellant's construction of the section. Firstly, that the construction which does not ask one to get into the issue what hypothetically might have happened had the law been different some years back. The disregarding of those issues leads to fair and consistent and rational results, because firstly, one's not led with having to test or verify hypotheses which may be very difficult to test and verify. And secondly, one's not faced with the evident unfairness of treating differently the present case of a person who apparently attempted to register a birth and the case of persons who made no such attempt because they thought it was doomed to fail. And I would respectfully agree with the members of the court who pointed to this as a serious difficulty in construing the legislation in such a way as to allow to proceed cases such as the present, where it's claimed that it can be shown that an attempt to register was in fact made. Those difficulties are avoided if one simply accepts that while, and I accepted this morning, while there's no carve-out from Section 5 and Section 4C, nonetheless, on rational grounds of workability and of the fact that one is not rewriting history, but merely rewriting the legal consequences of actual facts, on rational grounds, one can arrive at the appellant's construction of the section, and that is the construction which I commend to the court. Milady, apologies. Lady, I'm grateful for a moment. There's nothing I wish to add to what I've just said.
Thank you very much indeed. Thank you to everybody, both those sitting in the front row and those sitting behind you, who've clearly had a lot to do with the development of the arguments in this case. As I said earlier, it's going to be very difficult to decide which of these difficult constructions can possibly be correct, and I would also throw in my Lord's suggestion that if something is unintelligible, we have to decide what to do about it.
Well, we have to decide what to do about
Everything.
everything anyway.
True. So we will go away and try and do that now. And let you know the conclusion in due course. Court is now adjourned.